And tonight there is a big conversation to be had about a proposed bill that is being sponsored by the government, led by the Attorney General. It has to do with the legal profession. It's called the Legal Profession Bill 2021. And it has a host of radical reforms that Attorney General is proposing, including the controversial reforms to legal education in Ghana. The thing about this, though, this particular bill, is that it introduces a whole complexity into the mix, because there are several others who have also sponsoring bills on the same subject before Parliament. All of them are members of Parliament. Now, here's them. So you have Francis Xavier Sosu and Roxanne Dafiamepo, the two gentlemen. They were the first to put forth a private member's bill before Parliament on the subject of broadly legal education, right? And then we've also seen the second was what we saw today, which is that of the Attorney General. And by the way, so that is the government's own bill, right? That is going to go before Parliament for consideration. And then shortly thereafter today, we also got a sense, in fact, saw a third bill, which is also going to be a subject of parliamentary consideration. Again, private members, 3 individuals, 1 member from the majority side, Patrick Obama, and 2 from the minority side, Dr. Dominic Ayine and Muntaka Mubarak, sponsoring that bill. Now, so you already begin to see what may play out in Parliament. Possibly a clash between a government-backed bill and a bill sponsored mainly by minority members. And they diverge in what they're seeking to do. The divergence really revolves around what the Attorney General is seeking to do and what the two different groups here are also seeking to do. They seem to agree. I mean, if you look at these two gentlemen, these 2 members of Parliament, and these 3, the members of Parliament, if you read what they are all proposing, seem to largely agree on what needs to be done for legal education, generally the legal profession. The Attorney General is a departure, really, in terms of what he's seeking to do. And that's where we've seen some resistance tonight to what he is proposing. There's a resistance here because he is the Attorney General. And so he's communicating the thought, the wishes of the President of the Republic to Parliament. And that is why we're going to have a conversation about his, but throw in where it compares and contrasts with the others that we've seen also. Very interesting indeed going forward on this. Let's break it down for you, what the Attorney General is proposing to Parliament to do in terms of what it's in this legal professions bill. So the objective of this bill is seeking to provide for legislative framework for the recognition and licensing of a university to run the Bachelor of Law program. As it is right now, we don't have this. It is the accreditation board that does it. But they're bringing another layer of licensing, which will be given by the General Legal Counsel to this. Also, it will lead to the sanitization. This is what I hope, really, in the memo that is accompanying it. Hoping that to sanitize the growing universities offering the Bachelor of Law program and then provide for standardized way of monitoring these institutions to ensure optimum performance. But there are some exemptions, though, in terms of the bill when it comes to legal profession. Remember, this is not only about legal education, it's also about the legal profession generally, the practice of law in this country. It exempts lawyers appointed by the Legal Aid and Commission when it comes to renewal of licenses annually, lawyers in the legal unit of the Judicial Service also. Now, on legal education specifically, this is one of the controversial points in there, because it is now proposing to impose admission quotas on the universities offering the Bachelor of Law, which is, again, a very interesting point. We'll get into that very shortly. And then, obviously, if we look at the qualification for legal education, and this is, I guess, the big deal for a lot of people who are watching, on the back of all the controversies we've had with legal education and getting into the Ghana School of Law, where even there's a protest about the qualification when you do the entrance examination. The Attorney General is actually tightening the screws a bit more, introducing another layer of qualification to enter the school of law, which is you are not only, if he has his way, you are not only going to write an exam as a basis for qualification. After the exam, if you pass, you also have to sit for an interview. And the interesting thing about this is, this used to be part of the process of admission into the Ghana School of Law. And then it was scrapped. But the AG wants to bring it back. There must be a reason why he thinks it's good to bring back a procedure that was abolished in the past. We don't have him on the show. We hope subsequently we will, to explain this. But I'll get into the minds of my guests about what possibly may inform them. But we need to learn why it was scrapped in the first place. But that is very controversial indeed, right? Now, again, they talk about legal education committee, which will be set up, right? And the committee, the function, supervise the legal education in Ghana. And the committee shall hold office a period of 4 years. Now, the composition of this will be the Chief Justice, Attorney General, member from the Council, that's the General Legal Council, nominated by the Chief Justice, 2 persons nominated by the Minister, Attorney General, as being persons wide experience, both in law and other fields, and the Director of Legal Education will be in there. Then there'll be establishment of an independent examinations committee, which obviously will set questions and do other things facilitate at the education in this country. Now, then there's a recognition for law faculties. If you need to operate as a law faculty in this country, you have to comply by a few rules. You need to obtain a recognition license first before you can apply to the accreditation board. Now, approval by the Council for Accreditation for University. The university shall first obtain the approval from the Council, and then upon approval, it shall then apply for accreditation, National Accreditation Board. Now, there's also very interesting provisions about discipline of lawyers who are practicing in the country. A lawyer who is found guilty of professional misconduct, for example, is liable, as they say, be issued with a reprimand, be prohibited, have the name struck out. These provisions, I believe, exist already. But one additional thing that has been added here, which is interesting, is the fact that now, if you go before the disciplinary committee of the General Legal Council and you're found guilty, and you want to challenge it, as exists currently, you go to the High Court. Under this bill, you have to do it to the Supreme Court. Now, some say, in fact, Roxton Afemekpo has made a point that he sees a conflict there because the Chief Justice is superintending over the General Legal Council, but also the boss of the entire judiciary, but also other Supreme Court here panels. And so that may pose challenges because you end up before judges that he will empanel when he's also doubling, as holding responsibility at the disciplinary level. And so there are very interesting things to explore here. My guests are joining me. We'll get into this right after this. So stay with me. Don't go anywhere. And thank you very much for joining us here on PM Express. A very interesting conversation in the wake of what we've seen to be the tabling of a bill that the Attorney General, of course, the government is set to lay before Parliament, the Legal Professions Bill. I am delighted that I've just been joined by Dr. Dominic Ayine via Zoom. He is the chairman of the Subsidiary Legislation Committee and in Parliament, a sponsor also of a private members' bill on legal education, which I cited today. I'm happy that he joins us. He himself is a former Attorney General. I'm pretty sure he's seen the Attorney General's own attempt, a very comprehensive bill, though. His other colleagues are also sponsoring their own bills similar to what he's done. And so there's a very interesting, situation at play here where there are 3 separate bills on this matter, but there's a government. The key thing is that the government is also sponsoring one. I'll get his thoughts on the specifics very shortly. But I'm also very happy that Kukwan Sassari, who of course is a former director of the Ghana School of Law himself, but also now founder of Mount Crest, is also joining us because he's in the superintendent over a private university that offers the Bachelor of Law, course. And as you've seen, as I've illustrated, parts of the Attorney General's proposal will now impose quotas and also now imposes additional licensing for him, etc. I wonder what his thoughts are on this. But in the studio with me, Hassan Asare, who is the president of the National Association of Law Students. Thank you, Hassan, for joining me. In fact, let me start with Dr. Ayine. Doc, thank you again for agreeing to talk to us. You've seen this proposed bill by the Attorney General. First, give me your broad impressions of it. I'll come to your own bill and where they agree and disagree. But on the bill that Attorney General is tabling, what's your broad reactions to what you've read in there?
Okay, thank you very much, Evans, for this opportunity. I really wish I had the opportunity to come to the studio, but unfortunately, I had a lot of commitments in Parliament today. You know that this is a busy week for us in Parliament, so I could not join you in the studio. But to be honest, I cited the Attorney General's bill today. I have done a personal first reading of it, not the first reading that we are used to in Parliament, but a personal first reading of it. And Evans, what I can say for starters, and I would be reading the bill more thoroughly, and I think my opinions may change along the line, or they may stay the same. But what I can say for starters is that this is merely old wine in a new wine skin. What the Attorney General has done is to basically reenact the existing legal framework plus other, policy decisions and regulatory measures that have been taken by the General Legal Counsel and that have accounted for the problems that we are all seeking to solve. In fact, I think that the bill, if enacted into law, will exacerbate the problems that we are encountering now that we, in Parliament, think should be resolved, for the benefit of all Ghanaians. Okay. So, for instance, the issue of, licensing universities to offer the LLB, program. Okay. Now, this is intrusive in terms of the independence and academic freedoms of universities. All right. Because, for instance, you have the University of Ghana, an accredited university that, has been running law programs, and the Attorney General himself is a product of that university, just like myself. And then you now have a bill that seeks to say that for the University of Ghana to continue to run its LLB program, it must apply for, all right, and obtain a license from the General Legal Counsel for that purpose, all right. And then added to that, the Attorney General is also proposing that we have, a recognition license. Now, I am struggling to find out what is the difference between the licensing of the entire university, to run the program, and then the recognition of the law faculty for purposes of offering the LLB program. Okay, we can go into the substantive provisions of the bill, but from a purely regulatory point of view, what is the underlying regulatory purpose for saying that we will license the university as a whole? Say, Ashesi University, they do not have an LLB program now. They don't run, a Bachelor of Laws program. So we're going to license Ashesi University to offer the LLB program. And then we are now going, drilling a step deeper, all right, to recognize the law faculty or the law school of Ashesi University that is offering that LLB program. I am struggling to find out what is the, the regulatory purpose for that. What is the statutory rationale behind it? Now, secondly, Evans, there is the issue of quotas that the Attorney General is seeking to introduce in statutory form. The problem we have with legal education is a problem of access. Okay, and you have been covering these issues. Your entity, Joy FM, you've been covering these issues very regularly. You do know that our problem, the major problem is, one of access. Okay, the young man in your studio, the president of the Students Association. I'm sure he will testify to the fact that a lot of his colleagues are on the streets. I don't mean that literally, but they are on the streets with LLB degrees, and they are unable to, enter the law school because of limitations with respect to access. So if you are now seeking to introduce a quota system, okay, basically what you are trying to do is that you will predetermine the numbers that must enter the law school. Now, if you don't do so generously, then it means that you will cut down on how many students are able to, enter the law school and who can take the bar exam for purposes of determining whether or not they can become lawyers, in the future. Okay, so if you take what is into, this year's budget, all right, in the budget, the finance minister, I believe that the information was given by the Attorney General's department. Okay, the finance minister has stated precisely the number of law students who may be taking the exam and precisely the number of law students that the law school is willing to admit. All right, so 2,000 will be taking the exam. We are admitting 500 and we are graduating 200. That is a predetermined number. Okay, and so that is why we run into the popular 499 problem. All right, a situation where you have a predetermined number of persons that you want, and then the people who qualify are in excess of that predetermined number. So you must find some reason to exclude a number of them in order to get the number that you have predetermined. Even this is not going to take the country anywhere. All right. Under Article 25(1) of the Constitution, it is clearly provided that all persons, all right, it doesn't even say citizens, it says all persons shall have the right to equal educational opportunities. Unless the Attorney General is saying that professional legal education is not educational opportunity within the ambit of Article 25(1) of the Constitution, I think that he needs to take a second look at the major proposals that he's bringing, on the table.
So you've raised
and as you rightly, let me just finish with this one. As you rightly pointed out that in your intro, you said there were some things that were taken out because they were problematic.
Yeah, in fact, I want you to hold on first because that is so substantive. I want to get your colleague Kweku Asansari's view on the two issues that you touched on, because it falls squarely within his ambit now. Mr. Asansari, I'm grateful that you could join us. So those 2 points that are in the Attorney General's proposal now in this bill, because you, of course, superintendent of Mount Crest University, very renowned for offering the LLB. What's your own reaction to this bill that has been drafted now that will be tabled before Parliament by the Attorney General and the government?
Thank you, Ivan. Even before I state my position, I'll say that the entire bill at this stage should be withdrawn. First, because there hasn't been sufficient stakeholder consultation. What the Attorney General seems to be doing now is just to be, rushing a bill that has not been considered by the stakeholders themselves. That's my first point. And second point is that it seems to me that there's a lot of politicking going on with regard to legal education. Aine made a very pertinent point that the whole issue borders on access to legal education. Indeed, what the nation needs at this stage is to widen access to legal education in order to be able to confront or combat the numerous human rights issues that have confronted this country. Now, on the issue of licensing and recognition, I think these are panicky measures that the Attorney General is seeking to institute. Aine, again, draws attention to a very laughable point. We are going to license University of Ghana Law Faculty, the mother of law faculties in this country. How do you go about that? What is the government policy in this regard? Who is calling the shot? Now, if you close down or if you withdraw recognition for the University of Ghana Law School, What exactly are you aiming at? There's going to be a very huge uproar in the country merely because the premier law faculty is being shut down, for maybe lack of infrastructure, lack of inadequate resources, lack of, human capital and others. I mean, these are things that should not even, creep into the mind of the Attorney General. It's mind-boggling that the Attorney General will present or submit a bill, to Parliament without looking at the nitty-gritties, of the issues. Now, the second, the recognition of law faculties, as far as I'm concerned, I think that the measure the whole nation must consider taking will be to stop granting licenses to new law faculties. In other words, there must be a halt until we are able to address some of these challenges. We keep, talking about the problems, and then day in, day out, we are informed that new and newer faculties are emerging. So as we speak now, we have close to about 30 law faculties. We don't even have enough space to accommodate students or graduates from 10 of them. Now we have 30. What are we going to do with them? But more importantly, Evan, our problem is that we have never, ever been able to consider our manpower planning requirements. And therefore, up to now, we don't know how many students we should admit in 10 years' time, how many lawyers we should recruit in 20 years' time. Elsewhere, these things are planned 1,500 years ahead. Here, we rather do them in arrears. This is the problem. So, if we go back to history, we'll see that until 1992, when we increased the enrollment figure from 10 to 15 students, the law school, the PLC program, was limited to between 10 and 12 students, while the University of Ghana was between 26 and 40 students. In 1992, the enrollment figure was increased to 15 and thereafter to 20, so that by 2002, we had a total student population of about 80 students. Now, when the KNUST Law Faculty was established in 2003, there was a need to augment the lawyer population in this country. Now, as director then, I decided to break the jinx that only Lagos will train lawyers for this country. So we established the faculty in Kumasi amidst accusations and criticism here and there. Thereafter, many more law faculties have been opened. In addition to those that are already established, the Accreditation Board and the General Legal Council have together allowed other people to open or establish law faculty. I'm not against that. But when we have a problem, we should discuss the problem, dissect it, find out what is it that is wrong with the present system. How do we address the system? What is the way forward? And therefore, moving forward, we can say for the next 5 years, no new law faculty should be open. For me, my suggestion to the Attorney General is, please, if you want to solve the problem, for the next 3 years, no new admission to the law school. All those who've written exams and are now hovering around the corridors of the law school with very good passes, very good grades, admit them. some of them, like the 499, for instance, what do you do with them? October next year, they have to enter. I would suggest that in the face of that kind of problem, there is no need. There's no need to continue establishing new law faculties.
Let me ask you.
Rather than say that you license Legon or that you de-recognize Legon, just say that I am not going to open a new law faculty. I'll try and do my best to solve the current problems. And then if after we've found an antidote or solution to the problem, we can then consider, the issue of new faculties. The floodgate is, becoming burgeoning.
Let me ask you this. On the back of that, if you read this bill, and very briefly, it also proposes the imposition of admission quotas on universities such as yours. Is this something that you welcome?
Yes, for now, yes. Yes.
Okay.
Unless there's a quota, we are going to have problems. We'll continue to have problems. I disagree with those who are saying that merely because, we should widen access to legal education, we should just be multiplying the numbers. No, I disagree.
Okay.
If we want to improve quality, we should be dispassionate about this issue.
Okay.
Now that general should be the last person to take upon himself, this mantle. The Chief Justice should be excluded. We should get people who have no interest, in this matter. Now, the other issue that relating to the IEB, the Independent Examinations Committee, it used to be a board, a committee, that should be scrapped.
Okay, so you want to scrap? I mean, stay with me. Stay with me, Hassan. Sorry, let me quickly bring in Hassan Asari, who is the president of the National Association of Law Students. So on those 2 points, one, the quota, and then secondly, the licensing, that is to sanitize the space, right? I mean, you have an issue with that?
Yes. Well, let me just talk about especially the quota. Now, looking at the provision, there is in the bill as to how a faculty will qualify to actually get the license. There is a statement that says that the library of a faculty should have the capacity to seat at least 30% of the student body. Let's assume that it is the case that they are using that to actually determine the quota. So in this case, let's assume the number is 30. It means that you cap it at 100 for that particular faculty. Then it is fine. Where it is to penalize, then I have a problem with it. Because according to the same provision that was read, Article 25, all persons shall have the right to equal education. How do you limit it just because, in your opinion, you think it will bring out quality? I don't seem to get it. And in any case, we are not saying that we should push anybody who reads law, just reading law, for lack of a better description, even if you are stupid, we should push you to become a lawyer. That's not what we are saying. If we can get, I said it when I think you granted me that interview, if 5,000 people wrote the exam and only 10 passed, call them to the bar. However, if out of the 5,000, 4,999 also pass, you should still call them to the bar. So we are not saying that go with that mass perception of anybody can go. If the quota is to limit because the faculty does not have the capacity to contain them, then that is okay. But if it's going to just limit, for example, if
so it shouldn't be a quota for the sake of a quota.
Of course,
it should be functional. You assign a quota. But I guess if you think through it, they're possibly doing that because they are linking the LLB education capacity, the space, to the professional course space. So that if you have LLB students, will quota give 1,000, then you know that at least you have at least 800 people will go through that sort of thing.
But that would be an elitist mentality, because it only confirms the position that we are now. Because it means that in the end, if you are limiting it because you don't have the space up there, why don't you open the space? That is the issue of access.
But this bill doesn't do that at all. It doesn't.
I agree with you. I agree with you. But for me, as I've said, if it is for the purpose of trying to sanitize as long as capacity is concerned, then it's fine. But if it is just to cut down on the numbers just because you don't have space to contain those who are coming out, then I have an issue with it.
I mean, Dr. Dominica, there's another issue you were going to touch on, which I believe had to do with the reintroduction, or attempt to reintroduce interviews, which was scrapped some time back. And I remember you and your other colleagues were there when this was scrapped. Any idea why the Attorney General might want to bring this back?
Well, I think the reason is simple. It's another layer, that is designed to limit access to legal education. That is the sole purpose that I can, divine from reading the memorandum to the bill, as well as the provision dealing with that particular issue. I believe that the justification might come out that as much as possible, that layer ensures that those who pass the interview, will be the best, of the best. So, for instance, you pass the exam, it doesn't necessarily mean that you are good enough to go through to the law school. And so you are taken through an interview process that further gives the General Legal Counsel or the Board of Legal Education, for that matter, the, opportunity to sieve, the best out of the lot for purposes of admission to the law school. But I think, for me personally, that this is another layer that may block opportunity for young people to gain access to
Dr. Aine, what is your counter proposal? Because I know you've also tabled a private member's motion on legal education. What are you proposing?
Well, our proposal is a very broad and comprehensive one. Basically, what we are trying to do is to overhaul the system with a bill. This is not a motion. This is actually a private member's bill. So, the process in Parliament, if I may describe it in just 30 seconds, is that you first give drafting instructions. All right, that gives the broad outlines of the piece of legislation that you want to enact to the drafting section, and then they will communicate. And you write a memo to the clerk saying that you want to, table a private member's bill. Then the drafting section will translate the drafting instructions into a draft bill and consult with the member or members proposing to table the bill to see to it that the substantive content, tallies with what their vision is for bringing tabling the bill in the first place. And then when that is accepted, it is then transmitted to Mr. Speaker, who will admit it for laying, for the first reading, all right, and thereafter it will be given to the Committee on Constitutional, Legal, and Parliamentary Affairs for, deliberations and report to plenary, and then the other legislative processes, the enactment processes will go on. So basically, where we are now is the drafting stage, where the the drafting instructions are being translated into clauses, of the bill. All right. So our, major reason for bringing this, all right, is that we want to overhaul the system, and we are saying that the bifurcated approach that currently exists under the Legal Profession Act, should be discarded. Okay, for a process that is maybe for want of a better expression, a cradle to grave process, all right, whereby when you get your LLB, let's say from the University of Ghana School of Law, all right, after 3 years, now you do what we call the legal practice, and training course for another 1 year. And we are proposing that that course should be limited to the practical courses that are designed to equip the student with legal skills, to come out and be equipped sufficiently to practice law or to apply law, as a trade. And so we are proposing that it should be limited to only civil procedure, criminal procedure, conveyancing and drafting, and then advocacy and legal ethics. So, every law school will have a clinical program that is designed to offer the law practice and training course. And so you take that from, let's say, September of your fourth year, your fourth academic year, to June of that year. And when you have been certified by your clinical instructors as having passed, so that you can then take the bar exam. We are proposing that every student who has gone through the 4-year training, that is 3 years LLB plus 1 year practical law course training, all right, should be eligible to write the national bar exam. Just like the accountants write the, Institute of Chartered the Chartered Accountancy, whatever, part 1 and part 2 at the end of their, accountancy training. Every student who has done the LLB, every student who has gone through the practical law course that is in their own law faculty, okay? And there are provisions in the bill to deal with how you structure the law practice and training course in order to be able to equip the students with those skills. Immediately they pass the exam, we call it the LPTC exam, all right? Then they take the bar exam, the national bar exam, all right? Now, we are proposing that a body to be known as the Council for Legal Education and Training be established. And it should be detached from the General Legal Council. The General Legal Council should be in charge of the regulation of the legal profession, all right? That is the regulation of lawyers, as they, practice law, matters of discipline and so on, should be taken to the General Legal Council, all right? But legal education should be run by the Council for Legal Education and Training. Okay? And, what we have done, if implemented, will give everybody who has gone through the 4-year training program, okay, a bite at the cherry. They will be able to write the bar exam. And if they fail, just like we do with the professional courses in accountancy, in banking, and so on, they can resit the exam, all right? And then when they pass, they get called to the bar. Now, people are asking, so what do you do with the Ghana School of Law?
Exactly.
Okay. Certainly, the Ghana School of Law may remain relevant. So, for instance, we have people from common law jurisdictions such as the United Kingdom, Canada, the US, Australia, Ghanaians who train there. And when they come back home, they need, some training to be able to, write the Ghana bar. Okay. They can go to the Ghana School of Law. They are building a law village. All right. They can go there and then be trained, to take some courses in order to write the Ghana bar. Then also those who fail the professional courses and cannot go back to their various faculties can congregate there and be taught the law practice course, okay, in order to be able to, also take the bar. Okay, we can think about how we restructure the Ghana School of Law to make it relevant for purposes of professional legal education. But it will just be one of a number of institutions that can offer the law practice and training course, not a monopolies, that basically hinders access to legal education.
Do you have a proposal for?
That is what we want.
Do you have a proposal for how you enter? Okay, so is it a wholesale? Anybody who's done the 3 years LLB gets to do that additional 1 year. So there's no entrance exam and all those things that become an issue.
Well, you see, because of the academic freedom of universities, okay, we have to be careful what we try to push down the throats of those universities.
So schools are given the freedom to decide. So you're giving the schools.
Okay, so there are standard courses. Pardon?
Sorry, please go on.
Yes, there are standard courses that they're well over in common law jurisdictions that are offered at the LLB level.
Okay.
All right. We are not going to deviate from those, courses, right? And then also the universities can also decide that, for instance, if you get a second class, lower, you qualify to do law practice and training course. All right. But we have to leave that to the universities
to decide. Okay.
Of course, the Council for Legal Education and Training, in the process of accreditation, may also stipulate conditions of entry and say that, look, if a student obtains a third class, that student should not be allowed to write, proceed to the law practice and training course and so on. Okay. So we may have a grade point average that should be, should qualify you to do the law practice and training. Yes.
That's interesting.
So basically,
that's interesting. Stay with me. What's your reaction to this? So this is another bill that is also being. What's your reaction to that?
I think it's fantastic. It's one of the things we've actually been advocating for, which is to say, allow the faculties to run the PLC. So you look at it. And
then examine them at the end.
That's all we are calling.
And that's where you sift people.
It makes it easy because, as he puts it, if somebody got a third class, he said if we decide to implement that rule, the person will not cross that line. Beyond that, if we are setting, as he calls it, national bar exam, if we are setting the national bar exam, we know that this is the expectation. If you make this grade, you pass. If you don't make this grade, you fail.
Very objective.
But yes, but in doing that, I think we need to look at the issue of transparency at that end. Exiting, what will be the criteria? Will we have, like right now, we don't have the examiner's report, we don't have marking schemes, but I'm sure for his, as it stands, we'll have all these things that we can always refer to.
So the question, between his and the Attorney General's, as a student who's seeking, which one do you prefer?
The Attorney General's own only enforces what is existing right now that we are fighting.
Okay.
So I mean, it's not in doubt that we'll go for his any day.
Okay. So for Ansar, he says you withdraw it for now. Don't even go there. Let's start.
I support him 100%.
Let me go back to him, Mr. Sansari. So now you have not only the Attorney General's bill, you have a private member's bill. In fact, to be frank, we have two private members' bill. You've just heard Dr. Yine's bill. He's not doing this alone. There are two other MPs who are backing him on this. I mean, where do you stand on what you've heard articulated by Dominica Yine and what the Attorney General is also pushing?
I think that all three should be reconciled. You know, there are merit and demerit relating to it. Now, if the two private members' bill and the Attorney General's bill are synchronized, I believe that we can get something good, out of it. But let me address some concerns raised by Dr. Yine. First, what to do with the law school. We should always remember that the Ghana School of Law was not established as a university-oriented institution.
Okay.
The Ghana School of Law was established purposely for legal practitioners. For legal practitioners, not as a university-based institution. So the question of what to do with the Ghana Law School shouldn't arise at all, because the Ghana School of Law will continue to provide guidance and tuition, in the area of continuing legal education. The law school was established for continuing legal education purposes, and indeed, the pioneer student of, the pioneer 50 student, that intake was limited to only Ghanaians who had completed their legal education studies in England. The government barred foreigners from accessing the maiden course for lawyers. That was in 1958. Now, between 1958 and today, a lot has happened. Because of bad planning, the government, successive post-independent governments have not been able, to address the issues that Kwame Nkrumah, had in mind in making, Ghana a hub or a center, of excellence for legal education. So the law school must remain, the law school purposely for continuing legal education concerns. Now, what the other contributor made that we should have national power and this, that. I agree that, at some point in time, we should be capping, because we cannot, continue to say that in the name of access to legal education, just, John, Dick, and Harry, should be called to the bar. I agree with Dr. Yine we should go the way the accountants have done. They administer exams. They know how many people, to take. The only difference is that law is such a widely acknowledged universal profession that, permits the way of life, of society. You need, a lawyer in every sphere of human activity, just as you need an accountant.
Yeah.
You see the point. Therefore, now, if the accountants, are able to do this, and over the years they've been able, to solve their problem, I don't think, why the lawyers cannot. The problem the lawyers are having is because we have concentrated the administration and management of law institutions, including legal education in this country, in the hands of the Chief Justice and the Attorney General. And, I'm saying that it is a wrong approach. After so many years of independence, we should be able to acknowledge the fact that we have failed in this endeavor. We need new ideas, new ways of doing things. What are some of these new ways? I really mentioned, the establishment, of a national body to administer exams. That is fine. But I disagree, that we should introduce restrictions like you must be in possession of second lower before, you can. That shouldn't even, be, it's a non-starter. You don't need any restriction. Who says that, somebody with a third class or an ordinary pass cannot be a good lawyer?
Yeah, okay. So that's an interesting point. So in other words,
didn't come in at all.
Okay.
But what I will suggest as the short-term measure are the following. One, the law school or the General Legal Council should consider reintroducing or reinstating the National Service Certificate.
Okay.
As yes, one of the conditions for applying to write the exam. Okay. If you haven't done your national service, don't write the entrance exam. That in itself will address the burgeoning student enrollment issue. That is one. Two, therefore, between now and let's say 2025, there shouldn't be any entrance exam.
Okay.
Let's try to find placements for those who have been cheated over the years
and who are in the pipeline. I mean, sorry,
please, in the pipeline.
Please hold.
Find some remedial measure for them. No exam. Announce to the nation that until December 2025, there isn't going to be any entrance exam for admission to the law school.
Okay.
Now, all those who have passed but have not been able, to find placement to be invited.
Yeah.
Whether we give the refresher courses or not, we should find a way of putting them there.
No.
It's sickening that somebody.
No, Mr. Sorry, please hold on for me briefly. Let me bring in Dr. Ine because of time. Dr. Ine, Dr. Sansari raised a point earlier, which I want to put you finally before we wrap up, which is that you have a private member's bill. Attorney General has one, and then Roxanne Daffy and Francis Xavier also has one. What are you going to do about all these three? Are you willing, at least, as Sansari suggests, that you sort of pursue a certain joinder? I mean, merging all of them into one composite document for parliamentary consideration. At least, are you willing to do that? Very briefly, if you may.
Yeah, of course. I mean, I do agree with the former director of the law school, very experienced in that department. I think it's a question of timing. As we speak, the Attorney General's bill is in the public domain, but it is yet to be officially tabled in Parliament. All right. So it is not currently in Parliament. The two other bills, one is more advanced. The Francis Xavier Sosu and Honorable Dafiama bill is more advanced in terms of the enactment process. All right, that has I think been laid and referred to the Constitutional, Legal, and Parliamentary Affairs, Committee. In the case of our bill, it's on its way to the floor.
Okay.
All right. So depending on the timing, if they arrive at the same time, or if they arrive even one after the other, but within a short span of time, Parliament should be able to look at them together and then be able to take a position that we want to consolidate these bills. All right. And then make sure that they are enacted, into one big statute.
Okay.
One of the things that I think it may prove problematic from our point of view is that the bifurcated approach that is being adopted by, the Attorney General's bill is not, something that we want to support, and we will be galvanizing, support in Parliament to go against that. Secondly, I don't think that we should combine the regulation of professional legal education with the regulation, of the legal profession as a whole.
Okay.
In England, where we took this from, they have done the separation. The solicitors are even regulating themselves. The barristers are regulating themselves. And legal education is regulated separately. All right. And because of the growing demand for legal education, we need a specialized body that concentrates on a day-to-day basis on the two
separate aspects of it. Dr. Ayin, I'm grateful. This is definitely the start of this conversation. 3 different bills in 30 seconds. So you've had the various points. As a student, you see solutions in at least, Dr. Ayin. I'm pretty sure so what's the way forward now? The 499, they've been admitted now. Has there been clarity on when they're going?
No, we don't know anything.
Okay.
As long as we are concerned, they have been promised to be admitted, but as to when and the modalities, we are still struggling with it. Let me just chip in this quickly. I heard Mr. Ansari saying they should give a definite date as to when they will cancel the exams or they will cease. But you see, in 2018, when the LI 2355 was laid on the floor of Parliament, they said it was a stopgap measure. So how long must we stay with these things before we actually bring a closure to it?
Okay.
So I think it should be immediate. And as this PMB is going, it should be something that we should all support.
Hassan, thank you. Kukwan Sansari, I'm grateful. Dr. Dominic Ayin, enjoy the rest of evening, gentlemen.